Good day, esteemed doctors. Today we will provide crucial information to enhance your effectiveness when giving testimony on behalf of the Legal Department of the Ministry of Health. I'm Chusen, the Senior Legal Advisor, and allow me to introduce my team members who have been working diligently to prepare this informative video for you. Nik and Gar Fe, the Senior Legal Counsels, Wen Ni, the Legal Research Analyst, and Syaza Athirah, the Legal Compliance Specialist. This video aims to equip you with knowledge and strategies to enhance your expert witness testimony, ensuring effective communications of your expertise in the courtroom. Now, we will first provide a brief explanation of trial proceedings in court involving expert opinion evidence in Malaysia. A trial proceedings in court is a process conducted in open court where the parties involved present the evidence through their witnesses. In a trial proceedings, there are key processes. Examination in chief presents the evidence and testimony. Cross-examination challenges or clarifies the witness. Re-examination addresses issues raised, and both parties make submissions to the judge summarizing their evidence and arguments. To call an expert witness, a party presents the expert's qualifications, experience, and relevance to the case. The court evaluates their suitabilities and allows the testimony if their expertise is deemed admissible. In legal proceedings, a witness may be designated as an expert witness. Now, I'd like to hand over my esteemed team member who will delve deeper into the qualifications of an expert witness and discuss the different types of experts.
Good day, doctors. My name is Nik Nur Amirah. So, the relevancy of expert witness has been stated in Section 45 of Evidence Act 1950. Expert has been defined in this section as a person who has special skills in particular fields such as in the field of foreign law, science or arts, handwriting and finger impressions. Types of expert has been laid down in the case of PP against Sa'ad bin Matakro, which are the gazetted expert and expert under Section 45 of Evidence Act. Gazetted expert basically people whose appointment of their roles have been officially published publicly. The court will accept it as a prima facie expert without the need to lead evidence to prove their expertise. The example of gazetted experts is digital forensic analyst that has been recognized under Criminal Procedure Code. Meanwhile, for experts under Section 45, the expert must be skilled. However, it is not necessary by special study but can also be by experience. The fact that he acquired his knowledge professionally or not will affect the weight of evidence only and not admissibility. Besides that, semi-skilled or semi-experienced experts also may be accepted by court. However, the experts must be actual expert on the subject matter at the actual time or else it will be rejected by the court.
Good day to all extreme doctor. My name is Gar Fe. In general, a doctor may be called to testify as an expert witness in court when the cases involve scientific or medical issue which require a doctor's specialized knowledge. This is because usually the natures of evidence in these cases exceeds the common knowledge and experience of the judges. For instance, in Paramalai and Dr. Amajiko, it held that the testimonial of a medical expert would have been most material to the issues of concession in a medical negligence claim. Meanwhile, in criminal trials, R versus Mason held that the medical expert may be called upon in murder cases to give his opinion whether the deceased dies in consequence of his wound or from natural causes. Moving on, the court in Kujesuan and Kerajaan Malaysia emphasized the duty and responsibilities of an expert witness. First, an expert witness should provide an independent assistance to the court by way of objective, unbiased opinion in relation to matters within his expertise. Secondly, an expert witness should state the facts or assumption upon which his conclusions are based. Third, an expert witness should make it clear when a particular question or issue direct to him is actually fall outside of his expertise. Meanwhile, in cases where an expert witness who has prepared a report could not assert the report contained the truth or the truth without some qualification, the qualification must be stated in that report. Finally, if the expert witness changes his view on the matters at any time, such change of view should be communicated to other parties without delay and where appropriate to the court.
Good day to all esteemed doctors. My name is Chong Wen Ni, and I must emphasize that to qualify you as an expert witness, the counsel will ask you some questions regarding your professional background to demonstrate to the judge that you have at least the minimum qualifications to give opinion testimony on a particular subject and that your opinion is sound and supported with expertise. Hence, it is important for you to show confidence and be firm when introducing your background and answering the question. For a better illustration, we hereby provide you with some examples of mandatory questions that you would be expected to answer in direct examination. First, regarding your qualifications and background, the counsel is likely to ask you about your education, your current position in the medical field, the duration of your work in this particular field, as well as your prior qualification as an expert witness, if there is any. The counsel will also ask you with regard to a specialization, such as your area of expertise, your practicing years, seminars, or training related to your medical field that you had attended as a licensed doctor, as well as your research or achievements. After that, the counsel will examine your qualification regarding the matters of evidence. The question will be whether you have worked specifically with the issue at hand or how many similar cases you have been handled or involved. Moving on, you will be asked for your opinion pertaining to the matters of evidence. For instance, in a murder case, whether the deceased dies in consequence of its wounds or from natural causes, and whether the injury inflicted by the accused was sufficient to induce death in the ordinary course of nature to differentiate the accused's conduct in causing the death of the victim constitutes an offense of culpable homicide or murder. Whereas in a rape case, you might be questioned on what was the cause of such injury based on your findings when you mentioned that there was a laceration in the vaginal area of the victim and how you ruled that it was a male organ which penetrated the victim's vaginal area if you mentioned earlier that there was a laceration in the vaginal area of the victim. And further, whether the sexual intercourse was consensual or was it a forced one. Furthermore, in a child abuse case, the counsel might also ask you how you rule whether or not child abuse has occurred, and the risk factor did you consider in forming your opinion about child abuse in this case. In a medical negligence case, your opinion is required on what is the standard of care in the practicing field and whether the defendant's doctor has observed his standards of care. Furthermore, you will also be asked for your opinion on the causation and damages, for instance, whether the accident is the cause of the plaintiff's injury when assuming those facts to be true. Notwithstanding the above examples, kindly be reminded that the counsel will always ask you about the source of data, the tests you have done, and the theory that your opinion and assumptions were based on. Especially during the cross-examination stage, the questions directed to you by the opponent or defense counsel might be more oppressive with a purpose to temper your credibility. Nevertheless, we advise that you should at all times keep calm and feel free to request for a rephrase of a question or a moment of time to gather your thoughts before giving your answer.
Good day, doctors. My name is Syaza Athirah and I will explain several common issues that you may face during your testimony as an expert witness. An expert witness is often called to provide on the facts of the case regarding the knowledge and practical experience of being a specialist in your field. While at first glance it might seem like an easy thing to be an expert witness, but in reality there are a lot of things need to be considered. The first common problem you may face as an expert witness is that the opposite party might question your qualifications and expertise. They might question your education, training, work experience, or whether you belong to any professional bodies. In such a situation, you need to present a clear and verifiable evidence regarding your qualifications and expertise. Therefore, extensive preparation is required so that you will not lose your credibility in the courtroom. Second, you might face difficulties presenting information during the testimony, and as an expert witness, you will have a lot of things to say about the case that you have been asked to submit your opinion on. However, you might be tempted to use a lot of complicated terms which the judge will fail to understand. The advice here is that avoid using too much industry jargon in the courtroom. Otherwise, your opinion will not be valued as it should be. Next, you might be unfamiliar with legal courtroom proceedings. Nevertheless, it is common for such an expert witness to be nervous or anxious about what will happen during his or her court appearance. My advice is that a prior meeting with the lawyer or the prosecutor can ease some of the anxiety, as the expert witness can receive useful tips on how to explain himself or herself or respond during the cross-examination. Another common issue that you may face especially during the cross-examination, is that the opposing parties' counsel may use various techniques to challenge your opinion or credibility. They might ask leading questions, try to confuse or frustrate you, or point out any inconsistencies in your statements. Therefore, it is important to stay calm, focus on the facts, and respond truthfully. Besides that, another challenge that you may face is when there are several expert witnesses in a case. It is possible that your opinions may be different from other experts. In such a situation, usually the court may seek to understand why there are differences and will assess the credibility and the validity of each expert's testimony. Hence, in these circumstances, be prepared and do not panic to explain and justify any differences in your opinions. To conclude, being an expert witness is a challenging task, but you have to remember that your testimony can make or break a case. Meet with the lawyer and discuss the case as well as the legal court proceedings and your appearance. Ask questions in case there are any uncertainties and take your time to research the case yourself. Last but not least, make sure to present your opinion in a manner that is objective, transparent, and straightforward. That's all from us. Thank you.